For those of you who don't know me, I'm Carly Strauss, and for the past about 9 months, I've served on the consulting team who runs the coalition's day-to-day operations. On behalf of the Safety, Respect, Equity Coalition's leadership, I want to thank you all for making the time to be with us here today for our latest webinar. We're going to be discussing effective policies and guidelines. This webinar is part of a series that's going to focus deeply on various elements of the coalition standards. I want to extend my thanks today to our speakers, Fran Sepler and Sharon Masling, both of whom have committed their time and passion to this work throughout the coalition's existence. As we begin, I just want to share a few housekeeping items. We are recording this session, and slides in the recording will be available online next week. This is intended to be an interactive session. We've got time for Q&A at the end, but please do mute yourself while you're not speaking so that we can minimize the background noise on our call. And if you have any questions during the presentation, please ask them in the chat box and we'll share them out when we move into Q&A at the end. If you would like to ask them anonymously, feel free to chat them directly and privately to me, and I'll be able to share those out on your behalf. We'll also have a few minutes at the end if you'd like to chime up verbally with your own questions. Finally, I just want to share a few words on the coalition's path to this point before turning it over to Fran and Sharon. The Safety, Respect, Equity Coalition is a group of more than 100 Jewish organizations across the country who have come together to reduce gender discrimination and sexual harassment in our community. These organizations are spread from coast to coast, vary greatly in size, and include national organizations and movements, funders, JCCs, individual congregations, Jewish service organizations, and many others. The coalition's goal is to bring all of this work together under one banner, to serve as a catalyst, a convener, and a clearinghouse, and to lift up all of the good work that's already happening and support new solutions in the areas where our members are finding challenges. Our goal is threefold: universal leadership commitment, organizational change, and culture shift across the entire Jewish communal world. We're so grateful to have you on this journey with us. And today, I'm excited to introduce two experts who will lead us in conversation about how organizations can build policies and guidelines that set them up to be safe, respectful, and equitable spaces for all of their employees and community members. Sharon Masling is a partner and director of workplace culture consulting at Morgan Lewis, where she helps companies and organizations create safe, respectful, and inclusive workplaces. Prior to coming to Morgan Lewis, Sharon spent 8 years as the Chief of Staff to EEOC Commissioner Chai Feldblum. While at the EEOC, Sharon directed the work of the EEOC's Select Task Force on the study of harassment in the workplace, co-chaired their Harassment Prevention Action Team, and drafted and edited key sections of the agency's 2016 report on harassment prevention. Unfortunately, today, Sharon can only be with us for the first 30 minutes of our session, and we'll have to hop off to another obligation at the next hour mark, so noon my time. But we do appreciate so much, Sharon, you being here with us today, and we're really pleased to have our other presenter, Fran Sepler, here with us for the full hour. She will be here to answer all of your questions at the end. Fran Sepler is the president of Sepler & Associates. For 30 years, she has advised employers on the essential actions necessary to provide employees with safe, fair, and respectful workplaces. She is a seasoned employment investigator, consultant, and trainer who has worked in every sector: private, public, nonprofit, corporate, healthcare, education, and NGOs. Fran and Sharon, we are so pleased to have you here with us, and I'll turn it over to you.
Excellent. And thank you very much, Carly and SRE, for inviting us today. And my apologies that I can only stay on for half an hour. I had a call scheduled, not on my Tuesday, but I have to join. So today we're talking about policies. And obviously, there are many different types of policies that one could talk about. But today, we're specifically talking about policies regarding the prevention of harassment and the promotion of respectful workplaces. So, as you all know, policies can serve many purposes. We've highlighted 5 of them on this slide. The first is that a policy creates clear and uniform expectations. It puts everybody on the same page. It explains what behavior is expected in the workplace, as well as what behavior will not be tolerated. Everyone is on notice, and then if there needs to be an investigation or if a decision maker needs to evaluate behavior, they have a baseline against which to compare the behavior. Secondly, a policy will provide clarity on processes, on rights, on protections, on obligations. A good policy will explain how a person can file a complaint if they believe they've been harassed, who the complaint should be filed with, what will happen if the complaint is filed, and what will happen if a complaint is substantiated. They outline the rights of employees as well as the obligations of supervisors if they observe or become aware of harassing behavior. Fran?
So in addition to the sort of procedural guidance that policies provide, that opportunity for everybody to look at the same language and be instructed about how the organization operates, something really important and maybe a little more subtle about what policies do is that they cement something that we all want in our organization, and those are perceptions of fairness. Fairness perceptions are a really salient part of organizational experience. And we know that when people believe that they have been and will be treated fairly, it affects everything from their organizational citizenship behavior to their productivity, to their loyalty, to their willingness to take risks. One of those risks being to report behavior which might violate the policy. And just to sort of take this opportunity to talk about that fairness in a little more granular way, we recognize that fairness is made up of three different kinds of perceptions. One is what we call distributive fairness, or whether or not everybody is held to the same standard, everybody gets the same benefits, everybody receives the same protections. So in that clear and uniform expectation people that Sharon talked about, you're getting that sense of equity. I am not being asked to do anything anybody else is not being asked to do, and I am subject to the same consideration. Number two is transparency and voice. By telling people what it is that we expect them to do if they view something happening that shouldn't be happening, we give them a clear opportunity to speak up, to have a say in how the organization functions. And transparency is about explaining what will happen once you complain, that you're not going to go into a black box and then we're going to come out with a verdict, but rather there's going to be an investigation. Here's what the investigation looks like. Here's what you should expect. And then finally, explanations. People perceive fairness when decisions are made by organizations, and those organizations explain why they made those decisions, particularly when the decisions don't cut the way that an individual would like. So a policy is the beginning of explaining to people why it is they may feel that an injustice has been done, but the organization may decide otherwise. And good policies provide for clarity on what is it you will learn at the end of this process about why we made the decision we made. Some other purposes in our policies, or some other reasons we have policies, are just a way to allow people to clearly access resources. Where can I go? Who can I talk to? And what are the limits of privacy when I talk to someone? Where are our confidential resources? Do we have an employee assistance program where I can go and speak absolutely confidentially to someone? Or if I'm going to go speak to somebody else, what are the things they can do for me? And finally, I think policies are a way for an organization to widely advertise their expectation that people will be held accountable to both conform to the positive expectation of organizations, and when they deviate from those expectations or actually violate those expectations, that there is a clear possibility that there could be employment consequences up to and including discharge.
Okay. So we wanted to emphasize that policy making in and of itself is important, perhaps even more important than the policy itself. The process of making the policy, of identifying what are your values and stating your values, is extremely important. So when developing a policy, you should be thinking about who's going to be involved. Is it the board? Is it senior leadership? Is it a task force of employees at all levels in the workplace? The more people who have some level of input, the more buy-in you're going to have on the policy. Obviously, the words you use, the tone and the content of the policy will have an impact, but shared policy development and adoption really is an exercise both in compliance and in culture development. We wanted to underscore that every policy really needs to be tailored to the organization. So while we have given you a model policy, we really want to stress that is just a jumping off point. No one policy is going to work for every organization. The idea of sharing that policy with you was just to give you some ideas of what has been included in one policy, prompt discussion, have you determine what works and what doesn't work for your organization. So related to that, we also just gave you a list of questions to think through as you're developing your policy. Not every question needs to be answered in the text of the policy itself, but for each question, there should be an answer before you put the policy out. So that if you say every complaint will be investigated promptly, well, what is that going to look like? Who's going to do the investigation? How quickly is it going to be done? If there's a conflict of interest, what will happen? And all those other questions that underlie the policy should be answered as you're developing it.
And if I can just share anecdotally, the cost of not having that rich conversation before a policy gets implemented is not only a challenge getting people's buy-in to the policy, but you also run the risk of the people who most need to be familiar with the nuances of the policy not being familiar with it. And I think very clearly about an organization where I recently did an investigation in which an individual came forward and reported to a manager that they believed that they'd been subjected to discriminatory harassment within the organization. The supervisor they reported to happened to be a supervisor in HR, someone who they claimed they owned the policy. And this individual, who should have known better, looked at the policy and said, well, this person has indicated to me that they don't want me to do anything, so I'm not going to do anything about it because the policy doesn't say anything about me having to do it. And so this person who should have owned the policy and known the policy sort of was completely oblivious to the fact that as a manager, and certainly as an HR professional, once they knew that knowledge was imputed to the organization, they had an obligation to act, even if the person begged them to do nothing. So that conversation on the lead up to a policy helps you avoid some of those blind spots and also helps you realize what needs to go in the policy. So now let's talk about what makes a good policy. And I think that we all agree, those of us who work in this space, believe that a policy is an opportunity to talk about what it is you want from your people. Not just the things that are going to get you in trouble and not just the things that violate the law, but what your standards of conduct are. What does it mean when you say we want people to be treated with respect and dignity? The more you can parse that out into a statement that will help people understand your behavioral expectations, the more you've leveraged this opportunity to tell people those things that are going to make them excel, be valued, be successful. And then within that context, you certainly must describe then the things that are going to be problematic. Now, there is the legally compliant piece, which is to make sure that you articulate that anything that would be a violation of the law is prohibited. But as an organization, you can define misconduct any way you want that is not discriminatory. And so to the extent that, that you might have some practices that you as an organization believe, well, they might not be unlawful, but they certainly are unacceptable within our culture, those can go into the policies as well. Remembering that the policy is a tool for you to teach as well as a policy for you to enforce. Once you have laid out those expectations and you have been really clear and provided examples both of excellent and poor behavior, the next thing you need to do is to give people the toolbox to access the policy. Okay, I live here, you've given me an expectation, I'm now observing something that doesn't meet expectation. What is it that I'm supposed to do? And while some organizations opt to have certain people or positions named as recipients of reports, it is important to keep in mind that an individual can choose to go outside those parameters and report to any manager or supervisor, and that has been a report. So when drafting policies, if you're going to say you must go to your supervisor or you must go to the executive director, recognize that you're creating a little bit of a fiction because a report to any manager or supervisor is a report to the organization, and you're creating maybe an unnecessarily narrow band of people to receive a report. My view is that you should say go to any supervisor or manager you feel comfortable speaking with, and then maybe designate people who have special training. The other thing you must have is a bypass. If this policy compels you to go to someone who you believe either is harassing you or discriminating against you or is aware of it and enabling it, you may bypass that person and go elsewhere. And if you're a nonprofit and if your bypass for your executive director is to the board, it's really important that you have somebody on the board who isn't just by virtue of there being a chair of a personnel or audit committee in a place to get it. They need to have the training and nuanced understanding of what it is they're obligated to do when they receive that. Finally, for my part on this slide, we throw the words confidentiality around a lot, and lay people hear that this is a confidential process. And I will ask each of you to think, if you're not trained in the law or HR, when you think of confidential, what that means. And the answer is probably nobody will ever know about this. And that actually is not confidentiality, that's privilege. And there's really no place in your workplace, with very, very, very narrow exceptions, where you can have a conversation that nobody will ever know about, guaranteed. So it is really important that we use the proper language to explain to people that this is not a confidential or privileged process. Not only don't they have control over what the organization must do when it learns about it, but they also don't have control necessarily about who will know about their complaint. However, we also want to assure them that the organization will take every step necessary to limit unnecessary sharing of information. Sharon?
Right, and I just want to underscore that to do a good investigation, you're going to have to sometimes share information. If someone has been accused of harassment, if you're going to ask that person questions, almost by definition, you will be sharing what has been told to you. So you should assure the complainant that you will keep the information as confidential as possible, consistent with a good investigation. So a good policy also needs to describe what will happen if the misconduct is substantiated. So if there's been an investigation, if you find that there has been harassment, what will happen? Will the complainant be notified of what the investigation found? Will the person who's been accused be notified? Will there be corrective action, and what is the range of corrective action that can be imposed? So again, just describing what's going to happen if there's a finding. Some states now have passed laws that require that there be information about the different enforcement agencies an individual can go to. So yes, they should be encouraged to file a complaint internally, but for many reasons, people don't want to do that, and they have the right to go both to the federal enforcement agency, which is the EEOC, as well as the state enforcement agency. And in some states, I know at least Massachusetts, New York, and California, those three states and perhaps others require that information about those state agencies be included in your policy. And the last thing that a good policy must have is a prohibition on retaliation. So federal law requires, plus it's just good business practice, that there should be a prohibition that if someone files a complaint, that they will not be retaliated against. And if someone participates in an investigation, be it an internal one or one conducted by an enforcement agency, that they will not be retaliated against for their participation. And just good business practice is that if there has been a complaint filed against someone, you should explain to that person there has been a complaint, we are going to investigate it, but you should know that you are prohibited from retaliating against the person who filed the complaint. Even though understandably human nature is such that if someone files a complaint against you, you may want to take retaliatory action, you are prohibited from doing so. And that's really incumbent on the organization to let the person know that.
One of the deficiencies I've noticed in some policies I've looked at recently is that with regards to retaliation, it's twofold. One is it says these policies will often say you will not be retaliated against, which really you can't guarantee. Given the fact that, Sharon, what is it, 51% of claims with the EEOC right now are retaliation claims. We know that we're not very good at stopping retaliation. So it should say if you are retaliated against, that is not acceptable. And it also needs to say, what do you do? Where do you go? Particularly if the people responsible for enforcing the policy are the ones you believe are retaliating against you. And again, I think of organizations where you may have at the same time somebody having performance issues or attendance issues or conduct issues who's filed a complaint, and then HR or whoever is doing the HR function comes back and puts them on a performance improvement plan or writes them up for chronic lateness, and they say, well, this is retaliatory. They need to know, if I believe HR is the source of the retaliation, where can I go to get that clear hearing? So that's something to think about when you're putting that policy together as well.
Right, and one other just quick reminder is if there are performance issues with an employee, to document so that you can't, put someone on a PIP right after they have filed the harassment complaint. You need the information that there have been performance issues, that there continue to be performance issues, so that someone can't raise a retaliation claim.
Yeah, and also to parse out whether some of those performance issues are related to being the target of harassment. So one of the things you have to think about, everybody loves policies. They're easy, you can draft them, they are black and white, you can lay out your commitment really clearly, but it is really important that anything you tell people, any promise you make to people about the quality of their work environment is something that you can enforce and that you're going to enforce consistently. Very honestly, there are a lot of organizations that, if they were being honest, would have policies that say something like, our policy that applies to some of us but not the rest of us, or our policies are really nice to talk about, but in actuality we really don't hold ourselves to this highest standard. That hypocrisy comes right through as soon as somebody comes forward and says, look, you put this in writing, and what happens on the ground is differently. So as you draft your policies, and in particular, if you're delegating the drafting of a policy to a lawyer who's going to give you the strongest possible language, I think it's really important to do a gut check and say, is this something that we truly can hold ourselves accountable to? Or is this perhaps drafted a little more with a little more of a sort of aspirational goal than a real one? And so is this going to apply to everybody? Is everybody going to be held to the same standards? Do we have a culture in which we make exceptions for some people? And what do we have to do to recognize that we've given some people unearned privilege and to begin to clarify with them that that's no longer going to apply? Another thing is there's a tendency to over-legislate and write policies anticipating problems that don't exist. When you do that, you actually plant the seed in the minds of people reading the policy that, maybe there's a problem or maybe there's something I don't know. So do really try to keep it simple and to really focus on where the problems really are. Again, aspirational policies. I have seen people actually crumple up policies and throw them out and saying this is just not true. I've never seen this enforced, so they have to be believable. There is something that a lot of people aren't aware of, and that is the intersection between employment law and labor law, and how that might affect your policies. Under the National Labor Relations Board governs fair labor practices. And there is something called a Section 7 right, which is the right for employees to discuss the terms and conditions of their employment. This is put in place so that employees in any kind of organization have the ability to engage in concerted activity, which is about, should we form a union? Do you feel you're treated fairly? Do I feel my employer treats me fairly? And this particular provision gives employees broad rights to be critical of their employers, to describe to one another their views that their employer is unfair, to talk about things they've been asked to do or required to do. And so two mistakes that I see with some regularity is both instructions to employees that they may not discuss an investigation while it is going on, or they may not discuss their complaint with others, which is a flat out violation of the ability to discuss terms and conditions of employment, and anti-gossip policies that say that we're not going to gossip here. This is people who gossip are going to be subjected to corrective action or discipline. Gossip is protected activity to some degree. So too is you can't have a generalized civility code. So it is really important to make sure that you are not restricting people's ability to speak freely with one another. And there are very narrow exceptions to this. For instance, if you believe that there's a real risk of witness tampering, if somebody shares information, you can issue some instructions, but you should be well advised in doing that. And then finally, who owns the policy? If somebody has an issue with the policy, a question about the policy, believes that there's an error in the policy, who should they go to talk to? Sometimes policies are put out there as free floating, and it is really important that somebody know where the nexus of the policy is, so if they have an issue, a concern, a question, even if they think that there's something legally afoot, that they know exactly who to go to discuss it with.
Okay, another thing about a good policy is that it needs to be easily understood. Unfortunately, many harassment policies have been drafted by lawyers. I'm one of them, so I can say that lawyers sometimes do not write in plain English and instead use a lot of legal mumbo jumbo. But lawyers are not the audience for these policies. Your employees are. So the policy should be drafted in a way that your employees will understand. It should be plain English. It should be user-friendly. It should be in whatever languages your employees speak. Sometimes you will have employees who don't speak English. It should be at the literacy level at or below your workforce. Again, you may want to have very complicated procedures, but that's different than your policy, and your policy should be something that is clear, that people can understand what is expected of them and where to go if they have any concerns.
And I'm just going to editorialize very briefly here that a lot of the laws that we have seen coming out in the face of Me Too and Time's Up have been, I think, very well intended to try to push more information towards employees, but they have agitated towards very compliance-oriented approaches, including required language in policies and required components in training that focus at this very high level on what a legal violation is and what you can sue for. And as a matter of practical thinking, really, it is pretty important to recognize that no one has to make a legal determination as to whether or not behavior is unlawful before they tell their employer about it. It just has to be behavior they think shouldn't be happening. And so if you think about articulating things at that level, the language really changes.
I apologize, but it is 3 o'clock my time, so I must go to my 3 o'clock call. Fran will do a stellar job with the rest, and feel free to follow up with me afterwards if you have any other questions that Fran could not address for some reason, but I highly doubt that will be the case. Okay,
Bye.
Take care, everybody. Bye-bye.
And now it's just me. So I talked a little bit about limits on privacy and information sharing. The term of art that I would recommend that you use in your policy is need to know. This is really self-explanatory and it's very accurate. No one will know anything they don't need to know, and you will know everything you need to know. So when explaining this to people, I might say, if you tell me that somebody's got an offensive poster hanging in their office, I can go and look at that poster and ask them about it. And they may say to me, who complained to you about this? And I'm going to say, you don't need to know. You need to know that there was an objection to it, that I'm here to inspect it to determine whether it's a violation of your policy. And regardless of who complained about it, it is or it isn't a problem. On the other hand, if somebody says, John Doe touched me inappropriately, I can't really consider it fair to John Doe to say, well, John, have you touched anybody inappropriately in the course of your career? I do have to ask John Doe, did you touch Jane Doe? What was your interaction with Jane Doe on a particular day? Do you recall having any physical contact? And ultimately, if he says there's never been any physical contact, I'm going to have to say, well, Jane Doe has asserted that you made inappropriate physical contact. Can you respond to that allegation? So that's where need to know comes. And I want to go back and just reinforce that an organization must investigate a complaint even if the individual who brought the complaint has worries or concerns about retaliation or says, I only want this on the record, I don't want anything done. Once the organization knows or should have known, it has a responsibility to investigate. And this is something that should be made very, very clear in your policies. And it is also why you want to give people confidential resources if you have them. So if you merely want to discuss this matter with someone and you don't want any action taken, here are the resources. And that might be a ministerial resource that is connected to your organization where there can be a ministerial privilege. It might be your employee assistance program if you have one, where you have psychologists and licensed professionals who can afford a privilege. It may be simply referring people to community resources such as hotlines where they can be anonymous. But it is really important to clarify to people that this becomes the organization's concern once it's been brought forward, and sort of the notion that they own what will happen is fairly limited. Without managing that expectation, we can lead to people feeling terribly, terribly betrayed when we say, no, not only are we going to investigate this, but we're not even going to be able to keep secret that you're the one who brought it forward. So I do think educating people upfront about that is really important. So with all of the emphasis on sexual harassment, Sharon and I felt it was really important to clarify that if you're going to have a policy with regards to appropriate and inappropriate conduct, under some state laws, you need to have a specific policy prohibiting sexual harassment. But as soon as you start referring to your policies as sexual harassment policies, you begin to render rather invisible the majority of recipients of harassment in the workplace who experience harassment based on disability and race, the two most common forms of harassment in the workplace. There has been a lot of attention. I think we can make arguments that special attention to sexual harassment is meritorious, but I do think that referring to your conduct, your policies as anti-harassment policies or conduct policies or respectful workplace policies is very important. Also understanding that harassment is intersectional, and in particular, sexual harassment and harassment based on sexual orientation and gender identity have massive amounts of overlap as well. The other thing that I wanted to say, based on my experience working within the Jewish community, is that it is important to recognize that you don't have a pass on religious discrimination. There are cases, well-established cases and well-litigated cases that say that, for instance, treating individuals who are less or more observant than others within a particular denomination can be religiously discriminatory. I recently did an investigation in which individuals who had converted to Judaism claimed that they were being treated in a less advantageous way than people who were not converts to Judaism, and that's called a within-class form of discrimination. So if you are going to do education around this, particularly if you're in a religiously affiliated organization, this is an opportunity to educate folks that just because the majority of us are here united under a Jewish mission, doesn't mean that we're all Jewish to begin with, and we certainly can't distinguish between Jewish and non-Jewish folks in many aspects of their employment, with some exceptions. But even within the group of people who identify as Jewish, there are potential for us to discriminate based on religion. So we've been talking about anti-harassment policies, and those are what I call your have to. Under state and federal law, and sometimes under local law, you are obligated to have policies that prohibit unlawful behavior. When we look at the frequency, intensity, duration, and the outcomes of behavior in the workplace, I think it's fairly important that we recognize that sexual harassment, or harassment with a sexual element, is sort of one point of behavior that we prohibit. Harassment based on gender, which is hostility towards people based on their gender, words and actions which are offensive to people or put downs for people based on who they are unlawful when they are severe and pervasive. And so we need to prohibit those. When we take away the protected class, when we take away racial harassment, when we take away religious harassment, and we just have harassment, we have a massive swath of behavior that's extremely problematic. And that shows outcomes just as serious as unlawful behavior. So many organizations have chosen to not just have the have to language, but to make clear to their workforces that behavior that interferes with other people's ability to do their job and their sense of psychological safety is also considered to be a violation of the policy. Now, this may not have the force of law behind it, and certainly if an employer doesn't enforce this policy, an employee has little relief, because there is no legal protection against workplace bullying in any of our 50 states. Yet, if you really are about creating a culture where people can show up at work in their best selves, be productive, feel psychologically safe, feel that they're being treated fairly, feel that they're subject to equity, then we really do have a moral obligation to say you shouldn't be harassed for a reason or no reason. And so here we're dealing with behavior that is repetitive, targeted, and abusive. Many of you, some of you I've worked with, some of you I've consulted with, and some of you I don't know, but many of us are talking about building the role of active bystanders into our policies, encouraging people to speak up, to provide support or offer support to people they think may be targeted, to seek advice, to delegate concerns, to speak up in the moment. And if you're going to do that, I think several things are important. One is to identify an array of active bystander behavior. If you simply say being an active bystander is encouraged, that doesn't let people know that an active bystander can be as simple as saying to somebody, I see what's happening to you, can I help? It doesn't necessarily mean having a quiet conversation with somebody after an interaction or coaching someone. So if you're going to use the term bystanders, you should build in an array of permissible behaviors, and then you need to commit to non-retaliation. And that's a big ask for organizations. It's essential if you're going to promote bystander activity. But imagine, if you will, sort of the possibilities of somebody very inappropriately calling out somebody's behavior, and then when you try to coach them and say, you know, perhaps you might have been a little more diplomatic about that, or you might have done that in a way that was a little more respectful of the people involved, they might say to you, well, you're retaliating against me, and all I did was call out behavior I didn't think was happening. So give this some thought. It is a good place to go, but it does require some nuanced thinking and some training of your supervisors. And then finally, a lot of organizations are now going one step further than the law requires. As I've said several times, the law does require that when a supervisor or a manager is aware of a problem, that they take prompt and appropriate action. A lot of organizations are now saying it is our expectation that any employee who becomes aware of behavior which may violate our policy will report it. So this is an option you have, and it does essentially create a new expectation for employees that they will bring things to the attention of others, even if it didn't happen to them. And then I think finally, or maybe next to finally, we want to be sure that you cross-reference relevant policies. This stuff leaks into all sorts of other policies. Your social media policy should definitely cross-reference your respectful conduct policies, because many things that happen on social media can contribute to an environment that is harassing or bullying. If you have policies that govern consensual relationships, some organizations prohibit, for instance, romantic relationships between managers and supervisors and those they supervise. Others require that those relationships be reported to the organization, which is a whole another area of controversy as to when something becomes a relationship, but that's another webinar. If there are social restrictions that have been placed, for instance, circumstances in which individuals are not permitted to be alone with clients in mental health organizations, or where there are, wherein, for instance, counseling situations where there are things to control power imbalances, that should be cross-referenced. Travel policies, which govern things like room sharing, codes of conduct, which are sort of one level below policies, and conflicts of interest should all be cross-referenced in your conduct policies. And then finally, Sharon and I really wanted to point out that there is a temptation to want to put granular things in policies. I have had way too many calls saying, what should our policy be on hugging? And as soon as you write a policy on hugging, you're going to start having to deal with all of the nuances and exceptions that come to things like, you know, well, what if I've known somebody for 30 years and you know, I know that they're consenting to this hug? You know, what if I accidentally hug somebody because I forgot? You start getting into enforcing things that are unenforceable. I had somebody say, we're putting together a policy that says that nobody can have meetings after business hours. And I'm like, wait a minute, you're a nonprofit. You have a board of directors that is, many of whom are employed full-time. How are you going to get any business done? Well, we don't want our staff to feel coerced to have meetings after hours. Well, that's where your code of conduct comes in. This is where you start talking about what's desirable, what your expectations are, conceptually what's important. As to hugging, I don't think it belongs in policies. I do think a code of conduct should say that anytime anyone in our organization is making physical contact with anyone else, they should ask their consent and listen for an answer. If you're going to limit, if you're going to talk about hours of meetings, you should say that staff always has the discretion to decline a meeting that is being held in a setting or at a time that is not comfortable for them. So it is pretty important to make a distinction between what goes in policies and what you're going to put in your codes of conduct or your guidelines. You're going to get these slides. We have some resources here for you. The SRE Resource Bank, of course. Sharon mentioned that she was one of the co-drafters of the report of the co-chairs of the Select Task Force on the study of harassment in the workplace. If you have not read that, it is an exhaustive study. It is probably the most cutting-edge document out there in terms of efficacy of things like training and policies and approaches. And as part of that document, there are also an abundant group of checklists for employers that want to be engaged in best practices. So those are some of the resources we laid out for you. At this point, I'm open for questions. Carly, I hope you've collected some up for me, and we'll just see how that goes.
Thank you so much, Fran. We actually don't have any questions in the chat yet, so if anybody wants to chat them in or unmute yourself and ask, please feel free. I'll give you all a minute, or I also have a few that I can kick us off with. All right, well, Fran, I've got one that I'd like to kick us off with. You've talked about policies sort of highlighting both positive and negative behaviors, behaviors that you really want to see and behaviors that you really want to avoid. Particularly on that positive behavior side, what are some examples of things that organizations may call out as things we want to see?
So when we talk about the expectations for behavior, we can focus on a swath of behavior that universally gets identified as positive and respectful, so that the expectation is that individuals will consult with other individuals who are going to be affected by decisions. They will seek input from people who will be affected by those decisions. It might include things such as simple things such as acknowledging the people around them and calling people by their preferred name. It might include things like considering the individuals who need to be involved in activities, so that the expectation would be that when a meeting or an email is being formulated, that individuals will consider who should be on this distribution list, or who should be invited to this meeting that perhaps we've excluded. It will be about taking feedback and giving feedback to people. It will be about endeavoring to be good listeners. It will be about it could be about being timely and respecting people's space, whether it's their bodily integrity or their office space. It can be as simple as keeping common areas organized and clean. So this is an opportunity for an organization to say, what are the universal expectations we want to have here? And just as you do your enumerations of things that could go wrong in your harassment section, this is not meant to be an exhaustive list, but it's meant to be an example of the kinds of norms that create a respectful and positive work environment.
Great, thank you so much. We've also had a couple of questions come in via the chat. The first one is from Rabbi Mary Zamor. She's hoping that you can talk a little bit more about the balance between free speech and civil behavior.
Sure. So there is a right and I think an opportunity for people at work to speak freely. Freedom of speech is something the government affords you, not your private employer. So there is limited free speech in your employment world, but you are permitted to talk about things that are bugging you in the workplace, and you're particularly allowed to talk about those with your colleagues. The difference between thinking about giving people the capacity to express themselves and asking people to be civility is not really a matter of subject matter, but a matter of form and style. So that if I want to say this place is a sewer and everybody here is a jerk, I'm really not bringing my grievances forward in a very productive way. I can very civilly say, I'm really unhappy in this work environment, and I feel as though I'm not treated the way I want to be treated. And that should be a welcome conversation in the workplace, because if a manager hears that, they want to ask why, what's going on, what's happening that's deficient for you in creating for you the kind of environment you want to work with. And so we want to push people towards expressing themselves in ways that are productive. And we also have to have people realize how incredibly toxic sort of the broad, uncivil, rude negativity can be. Rudeness, labeling somebody or blaming somebody without an explanation actually forms a neurotoxic effect that lasts 8 to 10 days. And so when we say, well, that's just the way that person is and they can't help it, they're just rude, we're essentially giving them permission to poison other people's work environment. And I think it is only fair that when we recognize that that behavior has a toxic effect, that we say that it's unacceptable in the work environment, not to express dissatisfaction, not to have strong opinion, not to fail to express strong opinions, but to do it in a way that's additive and positive and not harmful to others.
Great, thank you, Fran. We've got another one that was messaged to me privately. Can we hear more about the event policy that was shared in the pre-webinar email?
Sure, that's sort of just a bonus policy I provided. This is something that a lot of organizations that have events, membership events, public events, galas, conferences have asked for. One of the things that I've discovered as I've worked more and more with academia, for instance, is that conferences are often places where people feel permission to behave in ways they might not behave in their home office. And anything from grossly rude to discriminatory to harassing behavior up to and including physical groping has been reported at conferences over years and years. And so it is fairly important that when you're putting together an event, you recognize that even though you may not be obligated to do it the way you are in an employment relationship, you are the steward of that environment for everybody who attends that environment, whether it's your own staff that is staffing it, whether it is your board of directors who is attending the event, whether it is members of the public who are coming and getting an impression of your organization, that everybody should have an environment free from harassment. And so by having this policy, A, you can make it available to people when they get ticketed for or confirmed to the event, to articulate the expectation, and also to give people that same understanding of if they're in attendance at an event and they're uncomfortable, where can they go and what should happen. This is particularly important at things like fundraising events, where there's often a sense of entitlement about how people might treat both volunteers and staff members. And it is at least the effort to say, we have a code of conduct here that's going to apply to you once you set foot in our events. And I should be clear that if there's harassment towards an employee at an event, as an employer, there's an absolute obligation to address that. But, and in some jurisdictions, your volunteers are going to be covered by that, but in some jurisdictions, your volunteers are not. So this would be a way to become more inclusive.
Great, thank you so much, Fran. And I'll just say from an SRE perspective, we actually have this and a few other model codes of conduct on our website and our resource bank, so please feel free to check those out. And we've also helped a number of Jewish organizations develop and present codes of conduct at their own conferences and events. So if that's something that you're interested in, please do feel free to get in touch with us, coalition@safetyrespectequity.org. Fran, the next question that's come in is, you said that employees should have a person or people to whom they report their harassment. What are the steps that the person who receives this complaint should undertake? And I'll just say really quickly, we are doing an entire webinar on this on August 6th. So we hope that you will join us. But Fran, if you can just give them a sample of the answer.
Sure. So there are two answers to that question. One is what we call the intake conversation. And this is a subject of my research over 30 years, I've interviewed more than 2,000 people who've complained to their employers about harassment. And we have established that there are certain things you absolutely should do and certain things you absolutely shouldn't do when somebody comes forward to complain, what we call the always and nevers. So the first thing you want to do is be sure that you thank the person for coming forward. You want to let them know that they've done a good thing for the organization. They've brought you a gift, and you respond just as you would if you've gotten a gift. You thank them, you show appreciation. You tell them, you know, just what you're going to do with it, even if it's not a gift you're really happy with. You give them confidence that this is something that can be addressed, and most importantly, you listen to them. What you don't do is try to solve the problem too fast. Because if you do, you're going to solve the wrong problem. Don't say, have you tried this? Have you tried that? Let them tell you what they came, let them tell your story. Don't try telling them yours. Please don't ever say something like, why didn't you say something, or why are you only coming forward now? We understand the psychological dynamics of harassment well enough to understand that these questions are both without cause and counterproductive. Some other little magical things we learned from our research is that two kinds of questions are really off-putting to somebody with a fresh complaint. One is any question beginning with why, and the other is closed-ended questions, such as, did you tell them to stop? So what you want to do is to say, tell me about what happened, what sort of things did you consider, what action did you take? And you do want them to go back to the beginning and make sure you get their whole story. The other thing, and this is just one of my little sort of things, is please never say to somebody, what was your part in it? It's about the worst question you can ever ask. And I don't think anybody's ever been asked that question and said, oh, now that you asked me that, I realize I brought this all on myself. And then once you have that full understanding of what the issue is, you want to let the person know what to expect. What are you going to do? Are you going to pass this on to somebody else for action? Are you going to take action? When is the person going to hear something back from you? Are you going to immediately say, well, we have an obligation to investigate this, and here's what you should expect? Are you going to say, I need to talk to so-and-so, I'll be back to you in an hour? But manage those expectations really carefully. And you always end that first conversation with this question: do you feel safe at work right now? If the answer is yes, it's easy. Let them go back to work while you deal with it. If the answer is no, you've got a project. You've got to figure out a way to get that person to safety right away, whether that is putting somebody else on leave, whether that is making a structural change that's going to be helpful to them. And for this, you're going to want some advice. Once you've done that intake, then the obligation is to assess the validity of the complaint. If everything you've been told is true, does it rise to a level where it violates your policy or the law, or it's unacceptable in your organization? If so, you've got to establish the facts. That means you're going to need to talk with individuals who've witnessed, either because they've been told about it, or they've seen it, or they've heard about it, or in some way are adjacent to it, such as somebody called and told about it afterwards. And of course, you're going to need to give the person or people accused an opportunity to present their perspective on things. Ultimately, you make a credibility assessment and you determine whether the preponderance of evidence suggests that behavior has happened that shouldn't have happened, and make a decision about what remedies are appropriate.
Great, thank you so much, Fran. Well, we do have a couple more questions. I also want to be conscious of time and note that we are getting to the end of our hour together. So to everyone who needs to hop off right now, thank you so much for being here. Fran, do you have a moment to stay on and answer? It looks like we've got 2 more questions.
Sure.
All right, so the first one is that one of our attendees has heard feedback from a local domestic violence organization that institutional policies are not victim-centered because of the need to investigate any reported issue. This makes sense because of the differences between privilege and confidentiality and privacy that you were outlining earlier on the call. Is there anything more to add to that conversation that might help the group understand that the best practice of needing to investigate and how that may or may not be in conflict with a victim-centered approach?
So Employment law places the burden on the employer to provide an individual with a workplace free from harassment. If an employer knows or should have known that there may have been unlawful behavior, they have an obligation to look into it. If they find that there's been a violation and they take prompt and appropriate action to stop it, there is no legal liability. That's how employers shield themselves from legal action. So no matter, unless it was a manager engaging in the harassment, in which case the legal structure is different, but no matter how egregious a coworker's behavior has been, if the employer addresses it as soon as it knows about it, stops it, and makes sure it doesn't recur, there is no legal recourse for that conduct. So it is important to understand that structure and why employers do things the way they do. And so the effort is always to be as sensitive to the complainant as possible, to whenever possible, limit information that's shared to provide safety to somebody who's brought a complaint. But it is not a situation in which it is an advocacy process. It is a fact-finding process that's really supposed to be neutral. And so it is only about the goodwill of the employer and the skill of the employer in terms of how that complainant is treated, and obviously protecting that complainant from retaliation. So the law itself is employer-centered, not victim-centered.
Great, thank you so much, Fran, for that clarification. And then the last question that I'm seeing is, in terms of this policy that you've discussed developing throughout this webinar today, what is the recommended name for the policy, and what are the best practices surrounding where it should live?
So I like respect in the workplace and anti-harassment policy. I think that sort of sets the high bar and the low bar. It should definitely live in an employee handbook if you have one, on your employment intranet if you have that, and it should go any place that any other policies, like your attendance policies, your lateness policies, your any other personnel policies, it should live there. And again, it should have a clear owner.
All right. Thank you so much, Fran. That is all of the questions I've got. Yes, and I know we're already a little bit over time. So Fran, thank you for being here. To all of our attendees, thank you so much for being here and learning with us. If you have any questions or would like to continue the conversation, please do feel free to get in touch with me or Fran. But thank you all and have a great rest of your day.